Today will not just be a conversation about paperwork and policy. It's about the dreams, aspirations, and the future of many individuals navigating the complex immigration landscape. So, stay right there to know more about it. Hello, everyone. Welcome to Immigration and Jobs Talk Show, where we bring you insightful discussions on various immigration topics. I'm Rajni Bharara, your host, and today we again have a special session with a very experienced immigration attorney, Prashanthi Reddy, where we are going to delve into a topic that holds the attention of many in our audience: the potential scenarios surrounding the H1B cap and the likelihood of encountering requests for evidence, RFEs, in the fiscal year 2025. Please join me in welcoming Attorney Prashanthi.
Hello,
Welcome, Attorney Prashanthi, to the show.
how are you?
I'm good, thank you so much, and I hope you're doing fine as well.
I am. Thanks, Rajani.
All right. So, everyone, please note that this session is being streamed live on YouTube, LinkedIn, Facebook, and the handle is Immigration Talk Show. And also, don't forget to subscribe to us. If you have questions to the attorney, wherever you're watching it from, please comment with your questions. We'll be glad to answer your questions. And now, all right, let's get started and let's dive right into the topic and take up our very first question. All right. So, as we know that today our focus revolves around the proposed H1B modernization rule by the Department of Homeland Security. So, Prashanti, could you tell us what are the key aspects of the H1B modernization rule proposed by the Department of Homeland Security, and most importantly, how might they influence the issuance of RFEs?
So, yeah, with reference to the modernization rule, we spoke about it a little bit in the last show as well, but to give more details in this show, there are three important or key aspects to the modernization rule that I wanted to touch upon. The first one is they talk about bringing back the contracts and work orders in a consulting company scenario where the H1s are being filed by IT consulting companies where the beneficiaries are working for third parties. The Previously, they would ask for contracts and work orders between all the possible parties, between the vendor, the end client, the sub vendor, and they would ask for these contracts to be valid for the validity of the H1. So if we're asking 3 years on a H1, they would ask for a validity of the BO for 3 years. Otherwise, they would give the H1 for a lesser time. So then in 2020, there was a lawsuit filed by IT Serve versus Cessna. And in this lawsuit, it was decided that it's unlawful to ask for the itineraries and detailed contracts. So USCIS agreed then not to ask for detailed itineraries and not to ask for contracts for the entire duration of the H1. As a result of which now H1s are being approved. They can still ask for work orders and contracts to a certain extent. They want to know if there is availability of specialty occupation work or not. And based on that, they can ask for it, but they haven't been doing that as much. But now with the modernization rule, they're trying to bring back that as a regulation so that the court order will then be null and void because there's an actual regulation to that effect requiring proof of specialty occupation work. And so they're trying to bring back those the requirement to provide contracts and work orders for the entire duration of the time. They have, however, have said that detailed itineraries would not be required, as the that information is on the LCA anyway. So you don't have to show that you have work for the entire period of time, but you have to show that you have some specialty occupation work. And then they might ask for contracts and work orders and MSAs and POs between all the parties involved if there's more than two parties involved. So that's one thing that is not good news. The second thing is with reference to how they define specialty occupation. So they've said that it's not necessary that the bachelor's should be in a specific field. They said
Mhm.
it could be in several different fields and it's still a specialty occupation as long as those different fields are related. Just to give you a background, USCIS has denied cases in the past where the job requires, for example, a bachelor's in computer science, engineering, math, physics. They say it's not a specific specialty, so it's not a specialty occupation. Now they're saying that as long as those um, majors are related, say computer science, electronics, information technology, as long as they're related to each other, the job can require more than one major and it'll still be a specialty occupation. So that's something else that they've said. So the specialty occupation, the POs and work order requirement, and no requirement for detailed itineraries. So these are some of the things that they've come up with in the modernization rule.
Okay, okay. And will the master's degree from US will be given more importance in comparison to the bachelor's degree?
No, it's still the same. As long as you have a bachelor's, the minimum requirement for a H1 is a bachelor's in the field that they're going to be performing the job in. There's no requirement that there should be a master's. The only thing is that when you're doing the registration
Mhm.
for the H1B registration for the quota, if you look at the H1B cap cases, there is a separate category for US master's degrees uh,
Mhm.
and that's a 20,000 additional cap. Additional numbers are available for master's degree holders, which are
Uh-huh.
not available for bachelor's degree holders. So what happens is if you qualify under the master's cap, excuse me, you'll be selected under master's cap. I mean, your lottery will be run under the master's cap, and if you're not selected, then it'll be run again under the bachelor's cap. So you'll get two chances at the lottery if you have a master's degree. So that's definitely an advantage. But from the point of a specialty occupation perspective, the minimum requirement is a bachelor's, not a master's. So that really doesn't make a difference. So also, I think your question also had a second part where
Right.
you were
Yeah.
asking the RFEs, how it impacts RFEs. So it's hard to say right now because remember the modernization rule is only a proposed rule. It's not something that has been finalized. They're still working, waiting for comments on the rule, and then they'll decide finally. They'll publish the final rule, so we don't know as yet. But if it stands as is, then it might impact some occupations. They might, even though it seems that they're opening up H1s to more occupations, it might actually end up restricting the occupations that qualify for a H1 because it depends on really how the officer then will use that kind of the rule that is proposed. So they can easily say that the H1B is not a specialty occupation because they can easily say that the majors are not related. So let's see how
Okay.
it goes.
All right. Okay. Also, I have one more question. With this particular question. So, given the change, given the changes, such as the shift to beneficiary centric registration system, what type of RFEs might become more common?
So beneficiary centric, again, that's one of the proposed rules, which I mentioned three. This is the fourth one. They plan to change the registration process, so that the lottery is picked not based on the registrations that are filed, but based on the passport number of the beneficiary. So if a beneficiary files for 10 registrations, that'll be counted only as one because they'll identify the five registrations as one through the unique passport ID, and
Mhm.
they will only run then that application one time through the lottery. So they'll count it only once towards the lottery. So it'll definitely affect. It won't really affect RFEs because when registration is doesn't have any RFEs, it's the H1s that actually have RFEs. So at the point of when registrations are done, the way it'll affect beneficiaries is that it's no longer useful for them to file multiple registrations, because whether they file 10 or they file one, they'll only get one pick, one chance at the lottery, one draw at the lottery. So it makes no sense anymore for the beneficiaries to file, multiple registrations through different employers. I mean, if they have separate job offers through each employer, then they
Mm-hmm.
can still do multiple registrations and only get one pick. And once they are picked, then they can decide which company they can file their H1 to if they've if they've filed more than one registration through different companies. So that's what's going to happen. No RFEs as such, because registrations don't have RFEs. So, and it doesn't affect once they get selected. I don't think it'll affect the H1 RFEs if, anyway they have changed the law. If they don't change the rules, then of course, if beneficiaries do multiple registrations, and if there is collusion between companies, so two companies decide to file for the same person,
Mm-hmm.
then there could be RFEs saying that there's collusion, and they could, um, then deny the case by showing that, the same set of beneficiaries applied through, two or more companies.
Okay, okay. All right. So now I would like to discuss with you about, the anticipating changes in specialty occupation requirements. So about this, I would like to know from you, how do the proposed changes to the definition and evaluation of a specialty occupation affect the likelihood of RFEs?
So I think since we already discussed about specialty occupation and how that's going to affect RFEs,
Mm-hmm.
we should also discuss about the other aspects of the modernization rule,
Okay.
which is the requirement for contracts and work orders. That can really increase the number of RFEs, because if a person is not able to show that, this is all in the consulting company scenario, of course. If the company is not able to show that they have a purchase order for
Mm-hmm.
that particular beneficiary with the name of the beneficiary on it, then it's most likely that they will get an RFE asking for proof that there is specialty occupation work for that beneficiary. And if you're not able to submit that proof, it's quite likely that then uh, the H1 will get denied after an RFE, because there's no proof that they actually have work for that beneficiary. So companies will be forced to get POs and work orders and submit them initially itself, so that they can avoid RFEs as we used to before, or not file cases if they don't have, if they're not able to show specialty occupation work for their employees.
Mm-hmm. Okay, but also, I mean, there was this thing that a bachelor's degree in a specific specialty is not always necessary, right? So, what additional evidence might be requested in RFEs to establish qualification for the H1B visa?
So they are saying that a H1B in a specialty occupation scenario, they are, I mean, changing the definition a little bit, and they're saying that um, it doesn't have to be a major in one specific field. It can be a major in several related fields.
Okay.
So they're kind of giving that leeway, but they might use that to our disadvantage. But in an RFE, they could be, for example, say that, okay, software engineer, just give you an example,
Uh-huh.
um, requires a bachelor's degree in computer science, math, and physics. So for the USCIS will say, it doesn't seem that they're related. Show
Mm-hmm.
us how it's related, that all these fields are related. Then you'd have to then give them a write up as to how these different fields are related, what is the relationship, what common subjects or coursework is present in these different majors.
Mm-hmm.
And perhaps you would have to get an expert evaluation, expert opinion, showing how math is related to computer science, for example. So
Mm-hmm.
that is how an RFE on those grounds could be responded to.
Okay.
You
Okay.
could also, I guess, look at the transcripts of a math degree and look at the transcripts of a computer science degree and point out a typical transcript, and then point out, how many subjects they have in common. And that way you could show, that's another way of showing that they're related.
All right. Okay. Okay. So thank you for answering this question, Attorney Prashanti. Now I would like to discuss with you something, some information about third-party placement scrutiny. So, in cases where an H1B worker is placed at a third-party site, how might the proposed regulations, okay, we have the question on screen as well, how might the proposed regulations increase scrutiny and RFEs, and how can employers, okay, firstly, like, let's take one by one, so if you can please answer this.
Um, how might the proposed regulation increase scrutiny? As we just discussed, if they're asking for contracts and work orders, and if there's more than one party involved, in that chain of POs and work orders, they might ask for contracts and work orders between all the parties involved. Sometimes there's a vendor, there's a sub vendor, there's an end client,
Mm-hmm.
so there might be three or four parties, and getting contracts between all the parties may not be possible for the employer because they have no control over all the parties. They might be able to just get their contract between their vendor, the end client, but not the contracts between all the other parties. So that could lead to a denial of the H1.
Mm-hmm.
um, and also, sometimes the duration of the PO may be only for a short period of time, and they might say that that doesn't show that they have specialty occupation work for the entire duration of the H1. So they could go back to saying that as well, and maybe they will then give H1s for a shorter period of time. They can scrutinize um, the contracts by calling the clients or calling the vendors to make sure that they have actually signed those contracts. And if they don't get the right person over on the phone, or if the person doesn't respond properly,
Mm-hmm.
they can cause issues for that could cause issues for approval of the H1 as well.
Oh, okay. Okay. But then how can they, employers prepare to justify the specialty occupation status in third party placement scenarios?
Specialty occupation is yeah, I get what you're saying. So you're asking, so basically, if a specialty occupation, you decide whether it is a specialty occupation or not
Mm-hmm.
based on the job description.
Okay.
And so who gives the job description? The job description is usually given by the employer. But since the person is not working at directly for the employer, but is actually working for an end client, they
Mm-hmm.
might want that job description to come from the end client directly.
Okay.
And if there's any discrepancy between what was filed in the as per the LCA and in the I-129 petition and in the description that the client has given, then they might deny the case, saying that, look, the job description given by the end client is different from the description given by the petitioner, or they might say that the job description given by the end client uh, doesn't show that a bachelor's degree in a specific field is required, and they might deny it based on that.
Okay, okay, got it. So thank you so much for answering the question, Attorney Prashanti. And I would like to tell the audiences that we are 20 minutes into the show, and I have asked, a few of my questions to Attorney Prashanti, but I still have a lot more questions to ask from her. But as I can see, a lot of chats flowing in from different social media platforms, LinkedIn, YouTube, Facebook, as I can see here on the right side of my screen. So now, what I would like to do is I would like to give my questions a break and rather take the viewer's question and give importance to the viewer's question. What do you say, Prashanti?
That's a great idea.
All right, so let's just jump into the viewer's question now. Okay, so first question that we have is from Make Deep Singh Goyal, and Make Deep wants to know what is the best option to go from TD visa to work permit.
So TD is, I think, a dependent of TN. Uh, I don't remember really, but work permit. So a TN is already, you're already on a work permit. So you already have, it's a working visa and you're supposed to work for that particular employer that has hired you.
Hmm.
So maybe they mean going to a green card, in which case then you have to file a regular labor cert, and the way you would do if you were on a H1, you would file an employment based green card, or you would file a family based green card if you have immediate relatives. And based on that, you would then get a work permit. So it's exactly the same as, if you were on a H1, you would have to go through. If you're doing an employment based, then you would have to go through the labor cert, the I-140, and the 485. But if that's not the question they asked, then they're welcome to ask it again, give us a more elaborate question, and we can answer that again.
Okay, so Megdeep, and also to every other viewer who's watching us right now from different platforms, I would like to request you that if you can please elaborate your questions. If you're sending your questions in short forms or in short ways, so we would want you to have your questions written in much more explanatory way, so that we can understand it, the attorney can understand it, and give you a better answer for your question. And now I also would like to request you that please make sure that your questions are related to the topic. I mean, I don't know if this question was related to what
I mean,
we
it is. It's a work visa, so I guess, yeah, we can
maybe
take it.
that's
Yeah,
yeah,
yeah.
maybe that's why the user asked. But I would like each and every one of you to please stick to the topic, so that we get a flow of the conversation, right? And now I would like to take another question, and another question that we have on the screen is from Vekant Naga Kamaraju. And Vekanta wants to know, I finished my master's in data science last month at Kent State, Ohio. I have 6 years of work experience back in India. Now I got my first job in USA with my joining date as February 12th. Will I be allowed to apply for H1B lottery this year? So, like, this is an elaborate and perfect question.
Right, I'm sure. Yeah, there's no reason why you shouldn't be. You've completed your master's, and you are obviously in status. You're in F1 status, so you can file under the master's cap. Um, if your university qualifies for master's cap. So yes, if your university doesn't qualify for a master's cap, then you can also file under the bachelor's cap. So yes, you will be allowed to apply for the lottery this year. Anyone can, as long as they're in status,
All right.
and they
So,
have to continue to maintain their status until October 1st. In the case of an F1, there is a cap gap rule, so that makes it easier for you to maintain your status as well.
all right. Okay. Venkat, I hope you have got your answer. Thank you so much for sending in your question. And now I would like to move to another question. So, the next question that we have is from G. Kishore. And Kishore wants to know what's the changes of H1B this year. So, I feel he wants to know that what are the changes going to happen in
Right.
H1B this year? Yeah.
Right. And we kind of discussed that. So it's a very
Mhm.
apt question, but we knew that people would ask us that question, and that's a hot topic. So we discussed that. We talked about the H1B modernization program. There might be, we talked about change in the way registration might be done. That hasn't, the other changes might not happen this year, but I think the way the registrations are done, and the fact that they might be picked based on the beneficiary's passport ID number. That might happen this year by them fast tracking that particular part of the regulation, not the entire H1B modernization regulation, but at least that part. So we're hoping that that will happen, so
Mhm.
that we don't have the same situation like we had last year.
Mhm.
Uh, so that's one change that we're expecting to see. With reference to others, I mean, we might see a change in the filing fee for registrations. It might go up to 250 from $10. Again, we need to wait and see. And then, you know, I don't see any other major changes this year other than that registration and maybe the fee increase. The rest will be pretty much the same, I think, with reference to approvability and what they'll ask, what documentation they expect for H1B.
All right. So maybe, Prashanti, maybe Kishore wants to know if there is any particular change that's going to happen that they might have to, worry about.
Like I just said,
Uh-huh.
nothing to worry about. These are
Okay.
the few changes that might happen.
All right. Okay. So you don't have to worry really, you really worry about anything. The changes that Prashanti has told you, you just need to take care of those particular changes. Kishore, I think you have got the answer for your question. Now I would like to move to another user. So the next user that we have now is Yasmin. So Yasmin said, my passport and H1 I-94 is expiring in July 24, same date, planning to travel to India and back in the first week of Feb. Is it okay to travel when I have less than 180 days passport validity left?
I don't think that is an issue to travel as long as you have a visa which is valid. Um, you know, but there is, with reference to the passport itself being valid, sometimes if it's less than 6 months, they might stop you at the port of entry. But it's
Mhm.
not so much an issue with the visa because as long as the visa is valid, it's always valid. Even if you have a 1 day validity, you can come back within that time. But sometimes airline folks and a CBP might stop you if it's less than 6 months validity for the passport.
Okay, okay. So, all right, Yasmin, I hope you've got the answer for your question. Now, after Yasmin, I would like to take another user's question. And this user that we have is from YouTube, and his name is Ajay Raj. And Ajay wants to know, I have CAP exempt approved. However, on I-797, it is only valid for 1 year instead of 3 years. Okay. And then is that normal or the employer will renew it every year?
It could be that, so nowadays they are giving H1s for the entire 3 years. In the past, if you were not able to show that you have worked for 3 years, they used to give it for 1 year sometimes.
Hmm.
But that's not the case anymore. So it looks like the employer might have filed it only for a year. I'm
Hmm.
thinking so. They should have filed it for 3 years, but if they didn't, then you'll have to renew it after, before the expiry.
Okay, okay. So Ajay, as Prashanti said, that you might have to renew, before the expiry. So I hope you have got the answer for your question as well. Now I would like to take a small break. I hope everyone so far this session is being helpful to you and is informative to you. And now, if you need any immigration help, don't forget to reach out to Attorney Prashanti Reddy. You can call her at 212-354-1010. I would like to repeat the number 212-354-1010. And you can also mail her at Prashanthi, Pranthi, as you can see it on the screen, Prashanthi at reddyesq.com, or you could also visit her website, which is reddyesq.com. And remember, if you're looking for a project placement or a visa sponsorship, you can reach out to me on my email, rajni at higheritpeople.com, or you can also contact me on 7 +1 732 707 9151. You can note down the details, or you could also visit our website, which is www.higheritpeople.com. Just remember, we also sponsor H1B visas and green cards. Now, we would like to take a short break, and you stay tuned. Don't go anywhere.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and today I have with me one of your favorite attorneys, Attorney Prashanthi Reddy, and she's answering all your questions related to immigration. And now, we are 30 minutes into the show, and we have also taken a short break. We are really enjoying your questions, and she is really enjoying. I hope she is enjoying answering to them. And so, Attorney Prashanthi, if you are, I would like to, move ahead to another user question.
Sure, sure.
Amazing. All right. So now let's take up another question. And the question is from Pawan. And Pawan wants to know, my I-140 got approved in October and then company got acquired by another company. Okay. As long as it is not withdrawn or revoked, can I still use the approval I-140 once 180 days met for H-1B extension?
Yes, you can, but he's a little confused about the facts. There's no 180 days required in order to apply for a H1 extension. You can apply for a H1 extension as soon as the I-140 gets approved.
Okay.
You're eligible for extension beyond 6 months. The 180 days is for AC21, which is if you filed a 485, if your I-140 is approved, if the 485 was filed at least 180 days ago, 180 days is over since the 485 was filed, then you can transfer your green card. That's the 180 days. It's not, there's no 180 days for this particular requirement to file H1 extension beyond 6 years. You can file it anyway, so you don't have to wait for 6 months.
Okay. Okay. That
And you
was
don't have to worry about it being withdrawn or revoked within 180 days. Even if it is, as soon as it's approved, you are eligible for to file an extension beyond 6 years on the H1.
okay. Okay. All right. So, Pawan, I hope you've got the answer for your question. And now I would like to move to another user. A lot of people are watching us from YouTube, LinkedIn, Facebook. We are getting a lot of questions. So, keep sending your questions. We are really enjoying asking your questions, taking your questions and asking them to the attorney. So, now the next question that we have on screen is from Akila. She has posted this question on YouTube and she wants to know, my H1B got RFE and my employer responded to it at the last minute. Now, as of March 31st, the status again changed as case is being actively reviewed. Please tell me how long is it going to take USCIS to give the result?
So once you get an RFE, if it's not premium processing, if it's premium processing, they should respond within 30 days, even though the premium processing clock stops once they send the RFE. But they usually do honor it and they respond in 30 days. If it's not premium processing, it can take, a few months for them to process it. So it could be, you can't say. It's really difficult to say how long it'll take. But um, if it's regular processing and they've already taken some time to review the case, then they should, and it's being actively reviewed, then it should be approved within a month or two, or they should send a response within a month or two.
Okay, okay. So it's just a month or two, Akila. I hope you're happy to hear that. And now, after Akila, I would like to take another user's question. And the question that we have is from, all right, Joel. Okay, Joel. I'm not sure if I'm pronouncing the name right or wrong, but anyways, coming to the question, I'm really sorry if I'm not. And my Joel says my perm has filed on 22nd Jan 2024, and my 6 year H1B expires in Feb 2025. Can I get approval till that time? If not, can you please let me know options for me?
So as of the date of filing, as of the date of your H1 expiry, if
Mm-hmm.
you have a labor pending or the process pending for at least a year, then you can apply for an extension of 1 year. So in your case, since you applied in January, as of February, it'll be more than a year. So you should be able to file an extension at that point of time, and you'll get H1 for 1 year.
Okay. All right. Thank you so much for your answer, Attorney Prashanthi. Now, I would like to move to another question that we have. All right. So, the next question is posted on LinkedIn by Vaina Reddy. And Vaina wants to know, I'm done with my master's in December 2022. Got a job with my first employer and have filed H1 on counselor, and it got approved. But now I had a job change with another employer and I'm still on my OPT. Can I do H1 transfer with status change?
You can file for a change of status, form F1 to H1, and you will not be subject, you should not be subject to the cap because you previously were counted towards the cap, and I think USCIS will allow you to do that. In the past, sometimes at times they have not allowed it, but I think now they've become more liberal with their definition of what is cap exempt and what is not. And in your situation, I think you are definitely cap exempt.
Okay, all right. So thank you so much, Vaina, for your question. And now I would like to move to another question that has been posted on. Okay, I would like to see it here on screen. I'm already able to see it on the right side of my screen, but I would also like you to see it. So it's posted on YouTube by Sanjeev Singh. And Sanjeev wants to know, my H1B was approved, but I-94 shows status as F1 visa. How can I know that my status has changed to H1B visa?
H1B was approved, I-94. Uh, I don't know why the I-94 shows F1. If your H1 was approved and at the bottom of the I-797, you should have an I-94 and it should say H1. I'm not sure why it says, why your I-94 says F1. I don't know where you're looking at it, where you're looking at your I-94. You should look at the bottom of your H1B approval. And if that shows as if that shows as F1, then they've made a typographical error on your approval, and you should reach out to USCIS.
All right. So, Sanjeev, like Attorney Prashanthi said, you should reach out to USCIS. Now, after Sanjeev, I would like to take another question. And another question is posted by Nitin Paul on YouTube. And Nitin wants to know, has anyone recently applied for H4 to F1 change of status within the USA? How long did it take to get the next step confirmation after case received?
H4 to F1. Yeah, so there's premium processing available for change of status to an F1. You can make use of that. If it's not premium processing, then it's difficult to. I mean, it's difficult to say how long it'll take. It could take 6 to 8 months. They are taking a long time for non-premium processing. Change of status cases, any I-539 type applications, they do take a long time. So I suggest that if you have not done premium processing, upgrade to premium processing.
Okay, okay. So, Nitin, I hope you have got the answer for your question. And now, after Nitin, I would like to take another question. So, the next question that we have is from Haley Rose, and Haley wants to know, she has posted this on YouTube. So, I would like to specifically mention so that, people should be aware that people are watching it on different platform on YouTube, LinkedIn, Facebook, so that if, just in case if any of your social media, one particular social media is not working, you can switch on to LinkedIn or Facebook. All right. So now Haley wants to know, received RFE during H1B transfer stating request for initial evidence. What steps should I take? Need guidance. If you can please
On-
guide her.
Once you get the request for further evidence or request for initial evidence, you will know what USCIS is asking for, and they will give you a time period within which you need to respond. So and then based on that, it's difficult to say what you need to do now because you have to actually look at the request for further evidence. You have to respond within the given period of time. You should respond completely to the RFE, not piecemeal. You should read the RFE carefully to make sure that you're reading between the lines and you're reading. Sometimes they have a lot of general information, and the information that is important they bury it, you know, in the middle of a paragraph. So you have to make sure you read it carefully.
Okay, all right. So Haley, like she said, you need to, read it carefully, and you need to take all the steps very seriously and follow them thoroughly. And now I would like to move to another question, and the next question that we have is from Shikha Singh, and Shikha wants to know how long is it taking for H1B RFE approval on premium processing these days once RFE is answered, and RFE requesting master's degree certificate to verify employment specialty occupation.
It doesn't matter why you got an RFE.
Mhm.
Most of the time, in your case, it definitely doesn't matter. The premium processing, as I said, they usually the clock stops. Premium processing clock stops. After they send the RFE, so they don't honor the 30 days. But I've noticed that if it's premium processing, they do process the RFEs also quickly, so they should respond within 30 days again or faster.
Okay, but Attorney Prashanti, I actually read it on Google. I'm not sure if I should say this or not, but I would like to, because since you're answering all these questions, I would also like to take up my question. So I read this thing that the Google was saying that sometimes it gets scary if the RFEs is being asked. So is it really? I mean, does it really get scary if the extra evidence is being asked?
No, it's not a scary thing. Sometimes I just want certain clarifications, or it could be that you haven't submitted what you need to submit, which you should
Okay.
have initially submitted. You didn't submit it. So, for example, a master's degree, by or a degree that qualifies you. Why wouldn't you submit that? So it could be in Shika Singh's case that she has education, but the degree is not in the related field, like we were discussing, specialty occupation. You have to have a degree in a related field, and that's why they're saying, "Do you have a degree in a related field?" So if you don't, then you may not qualify for a H1 unless you're able to show. You could also show that you have work experience that is related and get an evaluation done showing that the education plus work experience combined together is equivalent to a degree in the related field. Or maybe they think it's not related, but you can show how it's related by showing a job description, and then in a tabular form showing the relationship between the subjects that you're taking and your job description. Or
Mhm.
you can get a expert opinion as well showing how your degree is related. So there are many ways of answering this.
Okay, okay. But then, people should not think that if RFEs is being asked, so, there is something to worry about, or they might not get the
Not
visa.
always. Sometimes there could be something to worry about, but not always. So we can't presume that there's something to worry about simply because you got an RFE. Sometimes it's as simple as just, you send a foreign degree, you don't get it evaluated, and they ask for an evaluation. Or sometimes it's something really simple that you can actually respond to. Most of the times it's like that because, before you're doing a H1, you're evaluating it, or
Mhm.
your attorney is evaluating it to make sure that you actually qualify, that you meet all the minimum requirements, and that's why you're filing it. Otherwise, you wouldn't file it. So, most of the times RFEs are not scary.
Okay. And also, if you have, especially if you have, attorneys like Prashanti herself, it won't be scary at all. So you don't have to worry. You just need to take the guidance. All right. Now, coming to another question. The next question that has been asked is from Dinah, I suppose. Yes, Dinah, it is. And she wants to know that F1 to H1B stamping, are there more 221Gs?
I've not heard of cases going into admin processing for a F1 to H1 stamping, but a lot of people do go to Canada to get to get it stamped. So, but no, I haven't heard recently that there's more than usual 221 Gs or requests for further evidence on visa stamping. So as long as you qualify again, as long as your company is not blacklisted, and you're able to submit the documentation that they're asking for. Even if there is a 221G, it should still get approved.
Okay. All right. So, Dinah, I hope your question is being answered. And now I would like to tell to the audiences that, guys, we have 15 minutes left to the show. Now, if you have any more questions that you, excuse me, so if you have any more questions that you would like to ask from Attorney Prashanthi, please send in all your questions. You can post them on LinkedIn, YouTube, Facebook, wherever you're watching it from. And now I would like to take up another question. The question is sent from Anand. Yes, Anand. So Anand has posted this question on LinkedIn, and he wants to know: I have finished my masters, and I am in last year of STEM OPT, and I do only have one chance to file my H1B. I have a full-time job, and my full-time employer is filing my H1B. As I am in STEM OPT, I can work for multiple employers, and can I get multiple? Okay, I don't know if this the question is half. Okay. So as he said, I'm in STEM OPT. I can work for multiple employers. So is he asking, can I get multiple this H1Bs? Multiple
So you can
H1Bs?
file multiple H1Bs, but you have to decide which H1B you want to go with, unless you're filing the second H1B as a concurrent H1 and you decide you want to work for two employers at the same time. If you're filing one H1 after another H1, basically the H1 that you file the last will be the relevant H1. So you have to decide which H1 you want to file, or
Okay.
which H1 you want to use, and then the other H1 has to be withdrawn.
All right. Okay. So, Anand, I hope you've got your answer. Now, after Anand, the next question that I have is from, okay, the name is not mentioned. He or she is a LinkedIn user and wants to know: I did civil engineering in my bachelor's, and I have experience on software engineering. So, I am eligible to H1B. So, I think
You
he or she
might,
wants to know if.
you might, they might be eligible, Rajni, if they are able to get an evaluation done. If they have IT experience for at least 3 years and they're able to get an evaluation done, showing that the 3 years of experience is equivalent to 1 year of
Mhm.
1 year of a college degree, then you usually will be able to get a bachelor's degree, equivalent of a bachelor's degree in information systems or computer science,
Mhm.
from an evaluator, and that should be sufficient to file the H1. So 3 years of work experience in the IT field and get an evaluation done.
Okay, all right. Okay, so now after this question, I would like to move to another question. And another question that we have is from Tessa Sam. Okay, Tessa Sam wants to know: for F1 visa interview at Chennai Embassy, if approved, where will I get my passport, Chennai or Mumbai? And also, how long does it take to return? And is same day return possible?
Well, if you're going to Chennai, then you will get it in Chennai. The passport will be given to you in Chennai. And they should be able to give it to you the same day, unless there is administrative processing, in which case it can take up to 6 months or sometimes even longer. And during administrative processing, they return the passport to you, but they don't give you the visa, and instead it goes into um, an RFE kind of status where they might ask for further information.
Okay, so it depends upon the embassy. If it's a Chennai embassy, then the person will be getting the passport in Chennai. If it's in Mumbai, then Mumbai, right?
Correct.
Okay, all right. So Tessa, after thank you so much for your question. I hope it's clear now. And now moving on to the next question. The next question that we have is from Larina, and Larina wants to know: I am on I am an F1 student. Okay, I am on F1 student visa, and I will marry a green card holder soon in India. What would the first step to I have to do after coming back from India? And what's the green card process?
So, when you marry a permanent resident and you travel on an F1 visa, there could be problems because there
Mhm.
is an intention to immigrate when you're married to a permanent resident, even though you have not filed an immigrant petition. But
Mhm.
recently, they have said that they are not going to go after students, F1s, who have immigrant petitions pending. So let's see how that goes.
Okay.
But after you come into India, then um, just so I mean, the thing is, if depends on which country you're from. But
Mhm.
if the visa bulletin is current, then I would suggest waiting for 90 days. Um, you know, so that there's no intent problem. Um, and because then they'll say that you intended to immigrate and then you came on F1. So just so that they don't say that, then I guess what you could do is wait for 90 days, and then if you wait for 90 days, there may not be an intent problem, and then you file for an I-130 and a 485 if the visa number is available. Otherwise, you'll only be able to file for an I-130, and then you'll have to continue maintaining your F1 status.
Okay, all right. So, Larina, it depends on the country, as Prashanthi said. So now I hope you have got the answer for your question. And everyone, I would like to tell you that last 8 minutes to go. So if you have any more questions left, you definitely can pose those questions on different mediums. We will be glad to take them. And now, and also, I would like to inform you, which I already have. That if you need any immigration help, just don't forget to reach out to Attorney Prashanthi Reddy. You can call her at 212-354-1010, or you could also mail her at prashanthi@reddyesq.com. And you could also visit our website, which is reddyesq.com. And now, moving on to our next question. So, the next question that we have now is from this person called, can we have the question on screen, please? Okay, Mahib. Okay. So the question is being posted on YouTube, and Mahib wants to know, can an F1 student do a 20-40 hour off campus internship under CPT in a regular semester while already working 20 hours per week? I feel.
CPT, what is the 20 and what is the 40? Um, is my question. So, but in general, the amount of time that you can work on a CPT depends on your school and depends on their requirement
Hmm.
as to how many hours you require to work to get credits for that particular course, because CPT is something that is allowed by school because they think that because they it's part of the curriculum where you're actually getting training which is related to the job, to the courses that you're taking. So I think the school decides how many hours of CPT will be allowed.
Okay. All right.
Some schools allow you to do to work 40 hours a week, and then they have classes during the weekend. So it really depends on the school.
Okay. All right. So now, after Mahib, I have a follow-up question. A follow-up question has been posted by Anand. So can we have Anand's question on screen, please? Okay. So all right. So Anand wants to know that, but there are some changes saying that only one application with passport number will be going into the lottery, right?
Yes, they could be.
Okay, as simple as that. So, Anand, the answer is yes. It could be. And now, after Anand, I would like to take another question. Last 5 minutes to go, everyone. Please send in your questions. And the next question that we have is from, can we have the question on screen, please? The question is from Matrix Media. Okay, and the question is posted on YouTube. And Matrix Media wants to know: I have H1B Visa Stamp with with company A until August 2025. Switched to company B with I-797 approval until October 2026. When returning to the USA from India, can I use existing visa stamp from company A?
Yes, because as long as the company A visa has not expired, you can
Mhm.
continue to use the visa that you got from company A. But remember, keep in mind the expiry date on the visa.
Okay, so you can. Matrix Media, you can. Now, after Matrix Media, I would like to take another question. Another question is from Yashwant Patrick, and the question is posted on YouTube. And Yashwant wants to know, my H1B got revoked in 2023 November. And what are the options that I am having to extend my stay in USA?
It got revoked in November. And what is this person still doing here? That's the question, because the person is already out of status.
Mm.
You know, there is unlawful presence law, which says that if you're out of status for more than 6 months, then if you leave, you'll not be allowed to come back for 10 years. There'll be a bar. So you have to be careful. You should leave immediately, and then come in maybe on a new H1. Definitely November. This is December, January. So you've already spent 60 days, um, and there's been an issue. So yeah, my suggestion is to leave and then find a new way of coming back, whether it be F1 or H1, because if it's already revoked,
Mhm.
and if it's not because you've been laid off. If you've been laid off, or if you've left the company and that's why it's been revoked, then you have a 60 days grace. But if it's
Mhm.
been revoked by USCIS, or then there's a problem. But if it's revoked by your employer, you have the 60 days grace, which is
Mhm.
also almost over. November to December, so almost over, depending on when in November.
Mhm.
So you could also file a change of status while you're during the 60 days grace. You could file a change of status to a B2, to an F1. So those are some of the options that you have.
Okay, and if someone is there whose H1B is supposed to get revoked, in coming months, uh, are they going to have any what are the options that they would have to extend their stay in USA?
Like I said, if it's revoked by USCIS,
Uh-huh.
not much you can do. If it's revoked by your employer, then you have a 60 days grace within which you can either file for a H1 transfer to another company, or you can file for a change of status.
Okay. All right. So, Yashwant, thank you so much for sending in your question. Now, I would like to move to another question. The question is from Ashleen Uppal. So, Ashleen wants to know, the question is posted on LinkedIn, and Ashleen wants to know, I am a recent graduate with Bachelors of Computer Engineering. I'm currently working on a research project. Can I apply for H1B, or do I need a full time job before I apply?
You could apply based on a part time job as well. It doesn't have to be a full time job.
Mhm.
I don't know when you say you're working on a research project, whether that's a job or not. But if it's a job that you're being paid for, if it's a paying job, and if it qualifies for a specialty occupation, and if there is an employer, then you can. It doesn't
Okay.
have to be full time; it can be part time as well.
Okay, all right. Thank you so much for your answer, Prashanthi. Now, because we have only 1 minute to go, I would like to take my last question for the day. And I still have a lot more questions to ask, but we can ask them in the coming week, in the next show. But the last question that we have for this particular show is from Walter Ryan, and the question is posted on YouTube. And Walter wants to know, transitioning from F1 to H1 in October 2022. I on F12 applied for H4 in June 2023. USCIS issued an RFE after 7 months. Am I out of status? Will they deny my H4? If I return to India, will the consulate issue my H4?
So it looks like they filed a change of status from F1 to H4, and there's an RFE, and I guess the F1 is expired.
Mhm.
I'm not sure whether it is or not, but as long as when you filed your change of status, you were in status, then you're not out of status right now. Whether they'll deny the H4 or not, I have no idea why they issued an RFE. It really depends on that. If it's
Mhm.
something simple like show, relationship between proof of relationship between your spouse and you, like a marriage certificate. I mean, it depends on why they sent an RFE. If it's simple and you're able to overcome it, they will not deny it. You could also return to India and go to the consulate and get a H4 directly. As you know, there's no requirement to file a H4 with USCIS. You can go directly to the consulate and get H4 as well.
All right. Okay. So, Walter, I hope you've got the answer for your question. And that's it for today. So, there were a lot of questions pending, that I need to ask from Prashanthi. But because of the time constraint, I was not able to. But we're going to ask all these questions possibly in the next show. So, thank you so much, Prashanthi, for coming to the show and doing the show. I know you're very busy with your work and, a lot more things. So, thank you so much for taking out time and coming and doing the show. Means a lot.
You're welcome, Rajni. It's a pleasure as always.
All right. Thank you so much. And to you, our lovely audiences, thank you so much for tuning in to Immigration and Jobs Talk Show. We had a lot of engagement on YouTube, LinkedIn, and Facebook. And make sure that, you join every day, every week of our every live show, because we'll be, bringing a lot more topics, a lot more engaging topics for you, a lot more questions for you. But for now, I'll have to, give it a break, and I'll have to say thank you so much for tuning in. I'll be seeing you next week. But until next week, you just don't forget to subscribe to Immigration and Jobs Talk Show. Bye for now.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.